Hi, my name is Joe Lynyak, and I am a partner at Dorsey doing financial services work. It's really kind of nice to be at this type of venue because you see different disciplines. I never realized that securities enforcement was as much fun. I mean, in the first 5 minutes, they were talking about sexual innuendo and daisy chains. I mean, it's just absolutely amazing. We don't have as much fun, certainly in banking. But hopefully we're going to have an interesting presentation for you because right now the 600, 800, 12,000-pound gorilla is the enforcement actions being taken by the CFPB, and we're fortunate to have two folks with us that are working on it all the time from different perspectives. And the first part is going to be talking about the distinctions between the way the CFPB tries to kill you and the way that the prudential banking regulators try not to kill you but still take a reasonable amount of enforcement. Before we go into that, though, I'd like to introduce the panels. Right next to me is Ginny Lee, and we are just really pleased as punch the fact that she just joined us recently. She was an enforcement attorney, read Darth Vader, at the CFPB, where actually she was one of the rational people over there, but was heavily involved in examination, enforcement, and also policy development, and is going to be able to share her perspectives with us in a moment. And next to her is Dave Kogut from Charles Rivers Associates, who I've worked with extensively over the years. He does economic analysis, and he's a principal in the financial economics practice at Charles River. And he's really one of the bright shining stars in fair lending enforcement. And the lawyers do not drive the fair lending train. It's the economists that do. And he's going to share with you what's been happening and what's about to happen due to some of the extensive regulatory actions taken by the CFPB in the past. That's going to start to come into fruition in the future. I want to start out with the distinction between the federal banking regulators, the prudential regulators, and the CFPB. And perhaps the best way to do it is to talk about an anecdote about a long time ago. I was at the FDIC, and this is what they would do for community banks, because you probably all know a community banker, and they'll just pound their fist and say, "This is my bank. Nobody's going to tell me how to run this bank." And the FDIC comes in and says, "Look, you got to fix this stuff. Nobody's going to tell me it's my bank." You know, it sounds like, a Trump supporter. But anyway, at some point then, it's Saturday morning. They knock on the door of the directors, and they say, "Here's a civil money penalty for $500,000. Please pay Monday." I get a telephone call 30 seconds later saying, "Get us out of this." And that's what happens. Suddenly they roll over, they bark like dogs, and they fix the stuff they have to fix. But in back of it, though, is the fact that the FDIC doesn't want the bank to fail. And imposing large civil money penalties, it comes right out of the capital account of the bank, so the bank has less capital, and the bank can fail. So the FDIC, frankly, and the other regulators, the OCC, Federal Reserve Board, very rarely impose significant penalties. They use it as a big stick and they threaten, but they really never do it. Compared to our friends at the CFPB, where as of, I guess, a week ago, they have imposed over $11 billion in civil money penalties against folks. So it's a lot to write home about. It's an entirely different perspective. And before I turn it over to Jenny, the difference is the federal banking regulators are concerned with safety and soundness, the survival of the bank, the survival of the financial system. And the new kids on the block, the new sheriff on the block, really doesn't have safety and soundness concerns, and so they really act more like a sheriff. And you come walking down the main street, the sheriff shoots you. Having said that, now Ginny is going to give us our thoughts about the approach taken in CFPB in terms of enforcement and related issues.
Mm-hmm. Sure, actually, who ended up with the $11 billion? Where's that going?
Mm-hmm. You know the answer to that?
So that would be a combination of civil money penalties and restitution orders, and they go back to consumers who were allegedly victimized by any of the violations that were at issue, as well as any extra monies go into a civil money penalty fund. And under the Dodd-Frank Act, there are identified appropriate purposes for which those monies can be used, including if you and I both had enforcement investigations and my subject went bankrupt, and so several consumers had to take a shortcut on the amount of redress, where maybe you were the guy that did the multiple $300 million plus penalty against one of the banks that had the protection product cases early on in 2011. The CFPB has the authority to use any surplus civil money penalties that were obtained in your case to apply them to basically make up the shortfall for victims in another case.
And then
And how
also,
much has been dispersed?
but also too, if you collect enough money, you get a nice dinner at the pond.
Yeah, no doubt. Right.
No, there has been money dispersed, but they also have the same problem a lot of folks have of finding the people to send the money to.
Yeah.
So it's a process.
I mean, it's definitely a great point, because there's a lot of variance in how different cases are handled or treated, both in terms of the mechanism by which redress funds have to be disseminated back to consumers through compliance orders, as well as the way in which the folks internally at the staff level at CFPB handle the surplus funds in the penalty fund. And I think a recurring theme in our comments today is going to be the diversity in approaches within the CFPB, depending on what market is at issue and who is the lead attorney on the investigation. Do you get Susie Sunshine or the Hammer of Thor? It really colors the way the next 18 months of your life will be when you're handling an investigation. But before we get into the specifics, I did want to just make a comment about the prior two panels. With the CFPB, it's just been, I think, for CFPB practitioners, important to approach this new regulatory regime with a posture of humility. So you've got the SEC and the CFTC that's been around for however many decades, and the CFPB is only 5 years old. It was created under the Dodd-Frank Act of 2010, and its designated transfer date was July 21, 2011. So in the first few years, it's been remarkable to see both what the legislative experts and the policy experts have predicted that the CFPB would do in impacting markets and what has actually borne out. So to sort of bring us onto the slides, if we could fast forward to slide 10, I echo your comments about the differences between prudential regulators and the CFPB. Arguably, there's been a tectonic shift. We sort of had this massive sea change in how CFPB approaches regulatory markets in the financial realm compared to what had occurred before. The next slide was just sort of a calendaring to demonstrate the 5 years that have passed up to this date today. One of the key points that I wanted to make about CFPB enforcement is illustrated in slide 12. And what we have here are a couple of the main ways in which the CFPB has massively changed the regulatory regime that's available to federal regulators. One is that in the middle of the slide there, you'll see that there's a larger participant rule reference. Okay, so this is an ever-changing list of rules. So under the Dodd-Frank Act, specifically Title 10 of Dodd-Frank, which is the Consumer Financial Protection Act, the CFPB has been tasked to define those markets over which it has jurisdiction for purposes of instituting supervisory examinations. So the first few that they've done in the first 5 years to date are essentially deputizing itself to be able to go on site into new kinds of markets and conduct the traditional banking regulatory examinations, audits, come on site, take up an entire hallway office, be there for 2 months or more, and then come back every 6 months. And we've seen those changes occur in markets for, so far, credit bureaus, debt collectors, student loan servicers, international money transmission, and then non-bank auto lenders. And this is a complement to what already existed in the powers sort of the toolkit that the CFPB had, which was, of course, to also examine financial institutions that are depository in nature, DIs. $10 billion or more in assets is the jurisdictional threshold, as well as their service providers. And the second key expansion of the regulatory powers that came about by virtue of the CFPB is, of course, a new model of conducting enforcement investigations. We heard from the earlier panelists, and I was quite taken with the comments that were made about internal controls over at the SEC, and I think similar comments could be made with respect to the CFPB. What I've done on this slide is there's a blue box that signifies what's new in the sense of what Dodd-Frank gave the CFPB. So what I'm talking about now is this last bullet, which is that rather than there being a markets-based categorical set of definitions for what is the jurisdiction of the CFPB, now you have conduct-based jurisdiction. So I think the way I like to describe it is conduct-based because you can be the recipient of a civil investigative demand and a target of an investigation by CFPB enforcement attorneys who have independent litigating authority, who do not farm out their cases to DOJ, if you are a covered person. And under the statute, the CFP Act, a covered person has 11 different definitions with a bunch of different carve-outs and exemptions, but it essentially boils down to, are you providing a consumer with a financial product or service? So now you don't only have the Amex, Discover, Citibank type of enforcement actions, but now you have the telecom industry, Sprint, Verizon, any of these other kinds of companies that are providing financial services, even if they're not historically banking products, are now being targeted by the CFPB. In addition to that, of course,
is the consumer defined as the end user of the product? Or is there a definition of consumer?
There is a definition of consumer, and it is the way that the statute works is the provider of the service offering a financial product or service, and those kinds of services are delineated. So it's basically credit reporting, extending credit, brokering credit, payment processing, service providers to those kinds of industries. And the defining linchpin of the jurisdiction isn't really as focused on the definition of a consumer.
So, but would it cover rating agencies by any chance?
That I see you. Yes, it would not cover, I don't think, rating agencies because it has to be a kind of like a retail banking or some sort of a direct interaction with a consumer. I think that was your question. But that said, one of the frustrations that I think the markets have experienced is that enforcement investigators of the CFPB are very creative and very innovative about how to utilize indirect liability provisions. So under the Dodd-Frank Act, there are also means by which a service provider to a covered person. So you might have somebody who's developing credit scoring models, and that company doesn't itself. I'm not talking about the big three, Experian, Equifax, TransUnion, but about other innovative companies that may be a vendor, right, to a company that touches a consumer, but you yourself never touch the consumer. You're just selling that product as one piece of intelligence, knowledge, algorithms to help develop a better way to score consumers. Those entities would also be targets of CFPB investigations, even though they don't touch a consumer by virtue of being a service provider. So that's just one way that there's indirect liability. There's also other forms of derivative liability, providing substantial assistance, which is what yesterday's order with Citibank was all about, in the sense of Citibank providing substantial assistance under 1036A3 to debt buyers and debt collection realm. Besides those definitions, there's also related person and affiliate. So one of the challenges that I think the industry may face with regard to CFPB investigation is that you're oftentimes left scratching your head about why is there jurisdiction, and that's why it's always really important to look at how the CFPB staff attorney has crafted the pleading or has crafted the civil investigative demand in the sense that those really get signals on which direction that the agency is going.
So there's a broad area of secondary liability, aiding and abetting, and things like that.
Absolutely, and I think it is one area that is going to increase in nature in multiple industries.
Yeah, actually, a good example of their creativity is Dodd-Frank actually specifically carved out auto dealers as not being subject to CFPB's jurisdiction. But they've, through the banks that provide the financing or that indirectly provide the financing for the dealers are being, they're not being held responsible for differences in pricing in auto loans, but the whole model of that industry, the auto loan industry, has completely changed as a result of the enforcement actions that have been brought against the larger auto finance agencies and the way that they interact with the dealers and how that relationship works. So are rating agencies not covered? Somebody could get creative and say that they are.
I think that's a really good point. And so sort of to add on to what we've been discussing so far, in addition to the requirement that you have to be a covered person to be a target of investigation, it's important to note that anybody could get a CID. You don't even have to be a covered person to get a CID. You could be a third-party individual like a witness, or you might be a service provider, or you might be just a company that has in its possession documents that are relevant to any potential violation. And we've seen that recently. Earlier this month, the CFPB denied a petition by J.G. Wentworth to set aside a CID. The rules of the CFPB set forth an entire regime for how to set aside petitions, for how to set aside CIDs, or in the CFPB parlance, subpoenas. And it's important to note that even if there's not been an adjudication of a violation, or even if there's no basis for there to be CFPB jurisdiction over you, you still have under the regulations an obligation to respond and produce documents, interrogatories, create written reports, and produce.
Create.
Yes. One of the categories of information which the CFPB can obtain through CIDs are written reports that do not yet exist. That's, I think, let me see here. It's in one of, I want to catch up on my slides, but essentially, I think we're on slide 14. Thanks. And so if there are large quantities of data, say for example, payment processing data that deals with consumer accounts, credit card information, terms and conditions, the CFPB can require market participants to create reports that don't already exist in response to the CID. In addition, any person who has potentially relevant knowledge that could uncover a violation can be required to produce oral testimony as well. So you have basically pre-litigation depositions, pre-complaint litigation depositions that can be obtained through the CFPB procedures. And this is all possible even if you're not a covered person within the CFPB jurisdiction. Yes.
Question for you. So if, say I'm a financial services service provider.
Right.
What would be an example of the type of reports or CIDs that I could get related to creating the reports for the agency?
Sure. Let's talk about, as an example, a payment processor that services hundreds or thousands of other providers of a consumer product or service. In the past, there have been instances where a civil investigative demand will request a list of data, and you would be required to potentially put together an Excel sheet or some other format of a database which aggregates different data that the service provider may have residing on different computer systems. So that is a process of negotiation under the CFPB rules. There's a requirement to do a meet and confer after the receipt of a CID, and in that process, the recipient would negotiate the contours of the compliance for that particular report. Mm-hmm. So what is the limit?
There isn't any.
So if we're looking here, want to catch up on slide 14, the CFPB would argue that the limit is that it has to be information that would be pertinent to a potential violation of any federal consumer financial law. And what would that be? So if we could go to the next slide, please. Slide 15. The CFPB has the jurisdiction to enforce 18 enumerated statutes, including the alphabet soup of consumer laws, the Fair Debt Collection Practices Act, Fair Credit Reporting, Electronic Funds Transfer, Gramm-Leach-Bliley, Truth in Lending, Real Estate Settlement Procedures, and then many others. The CFPB also recently got in its bailiwick the Military Lending Act, and of course, the prohibition of unfair, abusive, or deceptive practices, UDAP. So the CFPB represents somewhat of I think it's a fair argument, of a hybrid regulator between the prudential banking regulators that can now come in and do on-site examinations, plus the FTC style of Section 5 UDAP litigation. And when the CFPB was setting up many of its policies and procedures inside the Office of Enforcement, I think the folks looked very closely at the precedents, the jurisprudence, decades going back, of FTC Section 5 jurisprudence. Yeah, please.
Just a note from the peanut gallery. One of the things that's really scary about the UDAP authority, and for those of you who have practiced in the FTC, you know this, but for a lot of you that have not, it doesn't have to be illegal. It simply has to be wrong in some qualitative manner, which means that you can have something which is a practice being operated, which could be best practices for all you know in the industry, but if an examiner decides that there's something the matter with it, it may be unfair to the consumer or whatever, it's still illegal under federal law and enforcement action can follow.
I think this point might be one where Joe and I have a legitimate difference of opinion, and our difference of opinion probably is in and of itself an embodiment of the distinction between federal prudential regulation and CFPB approach. UDAP, I think, is defined by the elements. So those would be the sort of key winning strategies that you would want to take, is look at the elements. So you can't just have an unfair practice because the CFPB feels like it. It has to be one where there's a substantial likelihood of injury to consumers with no countervailing benefit to consumers that could not be reasonably avoidable. And arguably, the industry is not as accustomed to a regulator mightily flexing its muscles under that power and really testing the limits of what constitutes those elements. Perhaps it could be argued that industry should do a better job of figuring out how to prepare in advance of any CID that's been issued or in advance of an examination. How are you going to shore up your proof and your data that this particular practice, whether it's a mortgage servicing error or a payment processing error or a deposit reconciliation error, how will you shore up the argument to the CFPB that there are aspects of this product that have countervailing benefits to consumers or competition? That's something which I think in the FTC unfairness jurisprudence was not particularly as well developed as the injury prong, but this is the kind of conversation which I think, as we stand at the precipice of 5 years after the creation of the agency and we look ahead to 15 years out, 20 years out, that's, I think, where the opportunities lie for industry participants to perhaps do a better job of being better prepared to answer when a crazy examiner wants to accuse a product of being unfair. But we've been talking about examinations and investigations. I want to just jump real quick to slide 18, and this is the rainbow spectrum of the possible catalysts of a CFPB investigation. In addition to the situation where a supervision examination audit within the CFPB could morph into a CFPB investigation, there are a lot of other origins as well. And if we start here from this blue slice of the pie, I'm going to start with the other regulators here. So internally at the CFPB, the folks at the staff level would be likely to receive a referral from U.S. Attorney's Office. Certainly all the U.S. attorneys and the AUSAs that are working on those investigations may come across a consumer protection component, financial component. The SDNY, Manhattan U.S. Attorney, has not been shy about prosecuting criminally those that are alleged to be violating the criminal laws in consumer finance. And there's also in Main Justice, Civil Division, Consumer Protection Branch. So anyways, I think this pie piece is just to illustrate that there are many federal regulators, not only the prudentials, but also other law enforcement bodies that have a hand in the pot of keeping an eye on whether or not consumers are being harmed. And the CFPB has a pretty robust mechanism internally to share information with those regulators in both directions and to utilize that information and evidence in deciding whether or not to open an investigation. Yes?
I noticed that the SEC is not listed as a potential partner. Is there no relationship?
That is correct. Well, so in the Dodd-Frank Act, it's a great question. There is an exemption for the jurisdiction of the CFPB for those market participants that are otherwise regulated by state securities commissions. So there wouldn't be as much of a relationship, I think there's certainly an MOU that the CFPB in the first initial starting years executed MOUs with multiple agencies, and there is a desire to coordinate, and in setting up the models that are used for how to do an investigation, the Bureau CFPB folks look to the SEC exemplars as guidance, but in terms of the substantive legal overlap, there wouldn't be as much.
Well, you have your secondary liability arguments.
That's a great point. So that's probably a topic which could form its own 60-minute panel, but up to this point, there hasn't been any focus by the CFPB on challenging that particular exemption of what the SEC can touch versus what the CFPB can touch.
You may want to explain ARC. I think that's really a very important point.
Oh, sure, absolutely. And we also wanted to go through the other sort of pie pieces here. The red piece of the pie here are basically, of course, consumers. The CFPB, as you know, views consumer protection to be the paramount driving mandate of its work and investigative and enforcement mandate. So you have mystery shopping in the sense of the CFPB being able to pose as undercover consumers, as well as consumer complaints that are reviewed and collected in databases that are shared between federal regulators. In addition, this yellow piece of the pie is a referral from examinations or fair lending. The ARC process is pretty critical to highlight here today. It's this internal process that is used that determines whether or not an investigation of a particular bank or a financial services company will remain in supervision and be resolved through the examination process, either through a non-public letter to the board of directors or a non-public report of examination, or whether that will be kicked over the transom and referred over to enforcement to be dealt with in an enforcement investigation, which concludes in a public consent order, and then very rarely in litigation in district court. And then, of course, this green piece of the pie is everything else. So the CFPB investigation staff could read an article in the Wall Street Journal or go to dinner one night and find that there's a particularly novel issue in a market within its jurisdiction and want to open an investigation. There's a protocol for doing that as well. The last point I just wanted to highlight today, and then I'll turn it over, is that this is in regards to slide 22. What we have here are 10 tips for how to deal with a CFPB investigation, and we'll refer you to those to review at your convenience. But there's just one that I wanted to highlight, which is tip number 5, and it's Head Start on NORA. NORA is a notice of opportunity to respond and advise. And at the conclusion of a CFPB investigation, you'll receive a letter from the staff indicating, we've investigated you. These are the things we have found. Now is your opportunity to present arguments in fact or law to change our minds. And it's similar, people have compared it to the Wells process in the SEC world. But our recommendation would be, you think about the NORA letter and what you're going to write in it as a response when you get the civil investigative demand, which might be 12 to 18 months before you actually get the NORA letter. If you only think about what you're going to say in NORA response when you get it, it's too late. Because that NORA response is the opportunity that you have to present your facts to senior levels, because the staff will have to attach that NORA response to its request authorization memo to sue or settle with a company. And that would be the arguably exclusive venue through which you can get your arguments, facts, data, information, correcting misconceptions before Director Cordray or before senior levels of enforcement and supervision.
What does NORA stand for?
It stands for a Notice of Opportunity to Respond and Advise. We've been talking a lot today about where the CFPB has been and where it's headed, and certainly one of the areas is fair lending, and for that I'll turn it over to Dave.
Yeah, so I'm an economist. I'm fairly confident that there are no other economists in the room. Is that... No? Excellent. All right. Are most other folks lawyers? Yeah.
I went to the University of Chicago as an economist.
Okay. Sure. Usually when I do these presentations, I'm one of the few non-lawyers in the room, so some people feel at that point obligated to tell lawyer jokes, but I don't have a job with that lawyer, so I find them highly inappropriate. Let's see. So one of the first things that the CFPB has done in the context of fair lending is they have greatly expanded the information that mortgage lenders are going to have to provide in their HMDA reporting. I guess I can't control the slides, can I? All right, so if you go to slide 32, back a couple more, 2 more, keep going. Actually, you're going the wrong direction.
No, I think it's going the right direction. You should be.
It's one that says additional HMDA reportable data. Anyway, so right now, mortgage lenders have to report on a systematic basis loan level data for every HMDA reportable application or mortgage application that meets certain criteria that they've underwritten or originated in the past year, and they do that once a year. Right now, the variables that have to be reported are fairly general. They give sort of a very broad overview of the type of lending that they're doing, who they're lending to, and what the denial rates were among those applications, mortgage applications. The scope of the HMDA reporting has changed to such an extent, or beginning, I think, in 2 years, such that now almost everything about the mortgage that they've originated or underwritten has to be reported. Characteristics that were not reportable before, such as very detailed information about the loan product, the price of the loan, what the note rate was, what the points and fees were, what the broker compensation was. This is all information that was not previously publicly available, and as a result, it could only be collected by a regulator or in the context of a litigation. Now this information is going to be publicly available to, in particular, advocacy groups and plaintiff side lawyers to perform analyses. They'll hire economists, not us, to perform analyses, to find institutions that their data suggests that they're at risk for having a fair lending violation. And as an example, that they're pricing loans to protected class borrowers, and here let's say it's female borrowers. Those prices are higher on average than loans made to male borrowers. And loans have a variety of characteristics and have there are legitimate reasons why rates might be different across loans, and you can do a statistical analysis, regression analysis to determine or to control for all those factors to the extent you can, and then determine what portion of the difference in the rates that have been charged are due to that borrower being a member of a protected class.
Dave, why don't you summarize what disparate treatment is? Disparate impact is in terms of how it relates to these.
Yeah. So if you have, for example, a lot of these initially these types of cases would be brought under disparate treatment, that you're actually treating borrowers differently because of their membership in a protected class group. Now that's shifted to disparate impact, where you'll be accused of having a policy in place that has allowed your loan officers, for example, to charge higher rates to different people, and well, it just so happens that as those rates have been set, and depending on who the customers of different loan officers are, it turns out that females are charged higher rates than males. And there's no allegation made that you have treated males or females differently. It's just that you have a policy in place that allowed this to happen, and because of that, because of these policies, a certain outcome occurred. So with this new data, as I said, the advocacy groups in particular, they're going to analyze it, and they will find institutions where based on the data that's available and the controls that they can include in their statistical models, have charged certain borrowers higher rates than other borrowers. And that difference can't be explained by differences in credit scores, for example, or loan-to-value ratios. So currently, this data, particularly with regard to pricing, there's really nothing in HMDA right now, in the HMDA data, that can be used to make allegations about different prices being charged. Now there's going to be a lot of information, and when these allegations are made, there's going to be more behind them. I think the fields that are being now going to be required to be submitted or reported are most of what we would ask for from a client when we, do a first pass of a fair lending review. So when allegations are made going forward, either by regulators, by advocacy groups, or by plaintiff side lawyers, there's going to be more to them, and it's going to be much harder to refute. And particularly with the regulators, once they find something in your data, they're very unlikely to let it go. It's very unlikely that you are going to, at that point, get a clean bill of health. So they will find, they might find a disparity among a group, a large group of loans, and you can explain that difference for a certain subsample of the loans, or you probably think you can explain it for all of them, but that they'll find something, some subgroup of loans where there is a problem that you have a hard time explaining, and you'll be held responsible and have to remediate the outcomes for those loans. It's increasingly the case that once some allegation is made, there's going to be some kind of settlement. Partly because there's just so little appetite for fighting it in the when the CFPB has made an allegation. It would be nice if a lender or group of lenders would litigate some of this, but nobody is willing to do that. Lawyers would really enjoy being able to litigate some of this so that there would be some precedent about what is and is not appropriate to do in the context of mortgage lending.
Well, I think you raise an interesting point, and there's a lot of judicial precedent in the employment sector for discriminatory practices. There's virtually none in the area of fair lending enforcement, and that's because if the government comes after you, you will roll over, play dead, and you will settle. And when you take a look at what we espouse as the rules of the road, they all arose, virtually all of them arose as a result of settlement. And the question still remains open whether or not there are some of these things which are espoused to be gospel, or at least Baltimore Catechism number 2, that this is correct practice in terms of the way we're supposed to be acting. And it really is a very, very significant problem in that, and the reason why what Dave is talking about is it is so burdensome if they come in and say, gotcha, that you absolutely have to have, as a matter of defense, an ongoing practice of doing this fair lending analysis. It absolutely is critical that you do it, because if not, the expenses fall off the table, your resources fall off the table, and you are organizing a massive amount of data, most of which I think in your experience oftentimes is bad, and you got to correct it.
It depends. Yeah, you don't want to be. Joe brings up a good point that you want to, you want to advise your clients to be performing the analyses that the CFPB or another regulator are going to perform, or advocacy groups are now going to perform. You want to be performing those in-house so that you know when these analyses get done, you know what the outcome is going to be, and you are prepared then to defend against whatever allegation is made. Or if you find problems that you can't easily explain, you are in a much better position to interact or to negotiate with the regulator if you've already made changes to your policies that will eliminate the problem going forward. You will probably still need to remediate what happened in the past, but you will be in a much better position if you've already dealt with the issue. So, you need to be doing in the context of mortgages or auto lending, really any type of consumer lending, statistical analyses related to underwriting, to pricing, and those require statistical models. You also need to be looking at, if you're dealing with brokers and you have third-party originations, you need to be looking at differences in fees that are being charged or that you're paying, how much you're paying to a third-party originator to incentivize them to give you a loan, because if you're paying a lot for a loan, you're going to have charge a higher rate for that loan. So if in a group of borrowers, they're dealing with brokers who you have to pay a lot of money to get them to send you loans, and the customers of that broker tend to be members of protected classes, it's going to be the case that rates for those loans are higher than they are for members of non-protected classes who are dealing with brokers who are receiving letter, don't need as much incentive to send you loans. So there are a whole bunch of, across a whole array of different lending outcomes. So again, whether or not you get a loan, what is the price of the loan, what were the fees that were charged on the loan, if you were delinquent on a loan, how were you dealt with? Did they lower your rate? Did they put you on a payment plan, develop a payment plan for you? Especially in that context, there's a lot of judgment that's made by the person that's determining what plan you're going to be put on or how the loan's going to be modified. Anywhere there's judgment, there's the possibility for differences in outcome. So anywhere where there's a non-automated decisioning process, there's a likelihood that you're going to have, there's a risk there that there's going to be differences in outcomes that you're going to have to explain.
One of the things that also is coming down here is that there's a difference between how the courts have interpreted disparate impact and an open question about how the government in its administrative capacity will do so. And you may be aware of probably the seminal case in the area, Inclusive Communities, which was decided last year by the Supreme Court. And they said that disparate impact is a valid means of proving discriminatory conduct. And the consumer groups were saying, yay, that's great, etc. But what the court then went on to say is that mere statistical evidence of discrimination is not acceptable for proof. You have to link it to policies and procedures of the entity that you're accusing. In other words, there's a causality factor in relationship between the statistical significance of discrimination and a policy and procedure. And what is an open question, which I don't know whether we have any answers yet, is whether or not the agencies, and even though I love to disparage the CFPB, it goes to all of them. It's DOJ, it's the banking, it's the banking agencies, etc. Whether or not they are going to follow that, give it lip service, or completely ignore it in accusing lenders of discriminatory lending conduct, because it really is a potentially significant aspect of defending a case. Do you have any idea where some of the agencies are going on it?
Sure. I mean, I think that certainly with the CFPB and its fair lending emphasis, I think that not only in auto loans, but now it's being expanded into other markets, their focus has been to reduce the amount of judgment that's placed in these credit decisioning systems and processes, as Dave mentioned, and to try to reduce the amount of discretion that the dealers have at the dealer level for how many basis points they can add on to a loan. And that's the approach that they've been taking, and I believe that they're they've been pretty consistent thus far with the inclusive communities warning in the sense of attacking a particular alleged policy of a bank and trying to demonstrate some causality. And due to the fact that this is a particularly highly politicized and controversial area of the CFPB's enforcement activity, and the manner in which the DOJ and CFPB work on ECOA cases, equal credit opportunity together. DOJ has FHA for Housing Act. Because of the manner in which they work so hand in hand, the DOJ would likely follow suit of the CFPB in trying to adhere closely to that warning in the back few pages of the inclusive community's opinion.
Yeah, Jenny brings up another good point that the policy goal here, there's clearly a policy goal here of eliminating discretion from lending decisions to the extent at all feasible. So again, there used to be, and not even that long ago, there used to be a lot of discretion available to a loan officer and what rate they could charge to a given customer, a given potential borrower. As a result of what the CFPB has done, and they've used that, the availability of that discretion as their causation, there is now, to a great extent, a push or a trend towards there being almost no discretion in the prices that are going to be charged for a loan, particularly auto loans and consumer loans. There's still some available for mortgages, but all of that is being squeezed out, and that is a policy goal that they have that it's something that could be achieved through legislation, but that's not going to happen. So this is how they're trying to achieve that policy goal, is through settlements where there's not a legal precedent set, but the parameters of the settlement create, in a sense, precedent for how lenders are going to behave going forward.
And by the way, for some of you that are interested, Dave and some of his colleagues had some interesting studies which are publicly available about the complexities of different categories of lending. Mortgage lending being pretty easy in terms of discretion, but then auto lending, direct auto lending, subprime auto lending, and for those of you who are interested, it really is very eye-opening about how difficult it is for these industries to function vis-a-vis the fair lending component, because there's so many discretionary actions, including, as we all know, the manager is in that other room. I'm going to go talk to him, and I'll come out and get you a good price. Yeah, sure. I mean, and you know how those issues come. So I would refer those to you as very, very interesting reading. Yes, sir, you had a question?
Jennifer, in cases where there is statistical evidence of differences and there is enough discretion to somewhat account for it, if there's no policy tied to that, because perhaps it is discretion, does CFPB have jurisdiction to charge individuals so they can't tie it back to the corporation through a policy? But if they're finding something, can they still go for blood?
The lack of a policy would be a policy, I think, is what their argument would be, wouldn't it?
I agree with that. I think that the practice or practice and policy in some ways are used as interchangeable words. So you had a practice of not having a policy. You didn't have a compliance policy. You didn't have a policy of oversight over your dealers or your representatives that were making these loans and had the judgment to be able to go talk to the manager and then get you a better deal or maybe not, depending on your race or other gender status. So
discretion, allowing discretion is the policy book in those cases?
I think that would be a fair,
yes,
based upon how they've written their previous consent orders, and it's fair But your point about individual liability is a good one in the sense, I mean, I think it's very important to look at the related person liability that the CFPB has been flexing its muscles under that provision in Dodd-Frank, that there's a lot of latitude. I mean, I think the enforcement staff would say, don't blame me, I'm just enforcing the laws as Congress wrote them. But under the related person provision, there are new and creative ways and some pretty major departures from how the prudential regulators have charged individuals in connection with the level of culpability that an individual had with an institution's alleged violation.
From our panel, any final comments? Dave?
No, any questions?
Jane?
Everyone's ready to go home.
No?
I think it's time for the Budweisers. Thank you very, very much, and I'd like to thank the panel for their comments.